Welcome to our second lecture covering the topic of labor law. As I think I highlighted before, labor law is really a completely separate area than employment law. It is every bit as complex and subtle as all of the employment law that we've been covering. So I'm trying to cram a tremendous amount of content in a very few hours. And so I know that I've been sharing a lot and I'm going to continue to share a lot, but honestly, it really would merit a full class. And obviously, there isn't enough labor activity in this particular part of the country to merit a separate class on it. But I am really picking and choosing. And so I know at the end of this program, you're going to be like, I don't really feel like I have a deep understanding of labor law. You're right, you don't. You have been introduced to some concepts, but it's been a brief look at the topic. If you have greater interest and you plan on going to law school, there will likely be a course in labor laws. I think I said before, I took um, two courses in labor law, I think three courses in employment law when I was in law school. So this was a topic that I did a deep dive into it. And I will tell you, even despite the fact that I took a lot of labor law courses, um, I I didn't really know a lot until I went out there and started practicing. I was fortunate enough in my career to have the opportunity to do a significant amount of labor work. Most labor and employment attorneys in this part of the country don't have that experience, and very likely, even if you practice in the labor and employment area, very likely in your practice you won't have a lot of experience either, unless you go to work for Southwest Airlines, or American Airlines. But anyway, it's very, very interesting, and I hope, if nothing else, you capture that it's a complex area of law, and that before you kind of get too enmeshed in it, you will recognize that you also need to get a specialist involved if issues arise. So, in our first lecture, we gave a kind of an overview of the history of labor law, and we talked about the Wagner Act, the initial part of the National Labor Relations Act. And now we're going to discuss union campaigns and elections, and that's still also part of the Wagner Act. This is the thrilling part of labor law. This is the part that gets people really, really excited. Union campaigns are very, very exciting activities. Now, I've only practiced on the employer side, and like many areas of the law, you'll find that there are people who practice exclusively on the employer side, and you'll see there are people who practice exclusively on the union side. It's very rare, I would say almost non existent, to find legal practitioners who practice on both sides. There are other areas of law that you will see people flipping from one side to another, but this is one area where you're on one side or the other side, and they are both thrilling sides. So, whatever journey your practice takes you, know that you'll be facing many of the same issues and many of the same challenges. So, let's get started. And to be honest with you, it's much more likely that you'll be on the employer side. There's just a lot more attorneys and paralegals who practice on the employer side than on the union side. And as a result, both because of my practice and because of the realities of where you're likely to work, I'm going to mainly be focusing upon the employer side of the activity. But that doesn't mean that there aren't lots of opportunities on the employee side or the union side. Most of the people who practice on that side are not likely to be paralegals. They are likely to be people called business agents, people who work for the union and who wear lots of different hats. Many of them will have gotten an undergraduate degree in labor relations. Cornell has an excellent school in that area. And so that career path is a little different. But I think a paralegal could segue into that area. It's just not the common pathway to take. So let's get started and talk about, what does a union organizing campaign look like? How is it likely to play out? Well, one of the big parts of it is that we're trying to persuade the employees of our particular side. And so this does involve lots of communication to employees. It's very much like a traditional political campaign. If you're running for Congress, you're shaking a lot of hands and kissing a lot of babies and doing a lot of stump speeches. Um, they're maybe even doing debates and things like that. So many of the same elements are going to be there in a union campaign. Now, you as the paralegal, if you're on the employer side, you aren't going to be engaging in these conversations, but you may be teaching the supervisors and managers how to engage in those conversations. You may be doing lots of role playing. You may be troubleshooting and fielding questions about what can be said and what can't be said. You may also be distributing, and not so much you distributing, but you may be preparing literature, handouts, campaign material that you can share with the employers. And many times these will be single page documents. Many times employees aren't going to be necessarily that interested in reading paragraphs of data. It's going to vary from industry to industry, but many times workers, especially if they're blue collar workers, reading isn't their thing. That's not what they find especially interesting. And they may see it, and if there's a ton of words on it, they may see, I'm kind of bored with this. I don't want to read this. So you're really looking for creative visual ways of communicating the information that you're trying to communicate. And of course, you're concerned about complying with the law, of course. That's an underlying assumption in all of these discussions. If you're on the union side, if you're working as a business agent, then yes, you can be involved and you will be involved in actually having these conversations with workers. There are less constraints on unions about what they can and cannot say, but it's helpful, it's essential actually for you to know the limitations that are put upon employers so that when an employee comes to you and says, "Hey, my supervisor said this to me," you're going to know whether that's a lawful thing to say or an unlawful thing to say. And if it's unlawful, you may suggest that that particular worker file an unfair labor practice claim. And we'll talk more about that as we go forward in these lectures. So it is important to do you know what the limitations are on employer conduct, even though there are relatively few limitations on union conduct during a union campaign. And the reason for that is pretty obvious. An employer has a lot of control over the employees. The employer can fire people, the employer can transfer people. And so it makes sense that the employer is constrained in what it can do because it has a lot of power over the workers. But the union, until it's voted in, has very little power. I mean, I suppose there have been cases of unions who have threatened to hurt people physically or threatened to fire people if the union does come into effect. But unless you're talking about pretty darn extreme behavior, there's relatively little controls on what the union can say. Now, from an employer perspective, I can tell you that feels really unfair, even though I understand the logic behind it, because unions pretty commonly will say things that are not legally correct and that they make predictions about things that probably won't happen. And workers kind of assume that what they're hearing from the union is correct, just like they kind of assume what they hear from the company is correct. Some people are more suspicious than others, obviously. What the employer says should be 100% bankable. It should be absolutely true. I'm not saying there aren't unethical employers out there, but for the most part, employers, at least ethical employers, are going to follow the rules. The union isn't as constrained, and so the union may be saying things that would not pass a fact check. And so it can feel, in that sense, unequal. But just keep in mind the rationale behind the inequality in this sense, and I think it does make sense. So another thing that can happen is the showing of support, and both sides are going to do this. I can remember we had a group of employees in one of the facilities in which we had a union campaign, and they wore T-shirts that had this on it in big letters. And they wore this every day. And you can probably guess what it means. I'm not going to shock anybody by sharing what it was. The company can't make people wear that or even offer it to employees to wear. But these employees on their own chose to wear shirts that had this message because they opposed this particular union. Union supporters also wore similarly clear messages about their union support. There can be some dress code issues. It is usually, I think, a practice to be more flexible in this area during a union campaign. But exactly what the limits are and how flexible you have to be is something that you need to do some independent research on. In one of our facilities, we had workers who had carts. They were what we called order fillers or order pickers. And they would fill their baskets with customer orders and then would drop those off on conveyor belts. And so they had something kind of the equivalent of a shopping cart. And many of those individuals chose to deck because they had kind of a dedicated shopping cart that they would use every day. So these workers would, for example, put pictures of their grandkids and their kids. Some religious people might put a picture of a cross or a Star of David or another religious symbol. Or they might have just a happy message on their cart, and the employer allowed the employees to customize their cart so it felt a little bit more homey, so to speak. After all, these individuals were pushing around this cart 8 hours a day, so it was almost like their personal office in a sense. So when it came time for union campaigns, the employer had to permit both pro and anti union communications on the cards. Um, and so that was a tool that the folks would use to communicate. If you allow customization, personalization, you're probably going to have to allow pro and anti union communications. If you allow anti-union communications, you probably ought to allow pro-union communications. If you don't have a strict dress code or a reason to have a strict dress code, you're probably going to need to allow some buttons and things like that. And you'll find, again, both sides will want to have the buttons. People feel really, really strongly about the issue of unions. You will have people who are adamantly and strongly and passionately in favor of the union, and you will have people who are equally adamantly, strongly, and passionately opposing the union. And this can cause not just obviously votes going one way or the other, but can cause tension in the workplace because these two individuals might have been best friends before the union talk began, and they might find that their friendship is frayed. Even if they weren't friends, just working together can be difficult because obviously the work continues and people still need to go to meetings with each other and they still need to share workstations and share supplies and do things like that. And so there are the opportunities for hurt feelings and loss of efficiency and angry times. And sometimes they will escalate into fisticuffs and yelling and other things that are not healthy, not safe, and not productive for the working environment. So, how to manage all those issues can be very, very complicated and very difficult to sort through them. You'll also find that one of the things that's going to become a real issue is going to be both petitions and authorization cards. We'll talk more about what authorization cards are and also kind of what petitions are. Petitions are oftentimes a more informal way of doing kind of what authorizations cards do. And unlike authorization cards, petitions can be both pro and anti union. But these are ways of drumming up support. Employers aren't allowed to directly do this stuff, or in fact, indirectly to do this stuff, but many times pro employer or anti union is another way of saying it. Workers may on their own start developing petitions and things along those lines. Authorization cards are going to come from the business agent, from the union. And these are basically cards that, if the employee signs it, is saying, hey, I want a union here. I want to join the union. And so these are important tools that the union uses to increase its support and also help it move closer to having that union election. And the mechanism that connects the authorization cards to the union election, and then we'll cover this in more detail in a second, is that the employer, excuse me, the union has to have at least 30% of the employees in the bargaining unit sign the union authorization cards. Although usually employers wait until they get to usually unions, excuse me, employers have nothing to do with authorization cards The union waits until it gets to over 50% of authorization cards before it actually petitions for an election. And the election is actually conducted by the National Labor Relations Board, a board agent, one of those individuals who are employed by the National Labor Relations Board. Typically, this person's an attorney, although the person doesn't have to be an attorney, but most board agents are attorneys. This person will become the election official, and he or she will run the election whenever it is scheduled. And the election runs pretty much like a normal election. It's a little bit less high tech. People will actually just write, in their vote and put it into a box in which the votes will be tabulated. It won't be electronic or things along those lines. But there will be secret ballots. People will be able to vote the way they wish to vote, and no one will know how they voted unless they choose to tell people. And pretty often, people will tell people they voted one way and they actually voted a different way. So even when someone says how they voted, it may not be meaningful. And so the election day is a very exciting part of the process, just like election night during a real political election. So let's talk about what an employer can and cannot do. Because as I said before, the employer is much more limited in the election process than the union. So the employer cannot ask employees what they think about unions. Now, I say here it's not per se a violation, but it comes pretty darn close to being a violation. And so, certainly, a smart employer isn't going to ask. Now, an employer is going to be trying to figure out what employees think because that's going to let the employer know how to most effectively campaign. What are on employees' minds? You're interested in seeing what employees who are on the fence are concerned about. What might be able to persuade them to vote in favor of the company and against the union? There may also be employees who are initially pro-union because they've only heard one side of the story. It's a little bit like if you have two people are running for office, Bob and Mary, and you've talked with Bob a lot, and you know why Bob thinks Bob ought to be elected. Well, you're probably going to be on Bob's side until you hear Mary talk, and maybe after you hear Mary talk, you may still be on Bob's side, or you may have changed your mind and now support Mary. And so, even employees who are initially pro union are oftentimes persuadable to not vote in favor of the union. And so, you're looking for what are they concerned about? What are they mad about the company about? Or what are they concerned about in terms of their own future? Usually, these employees will tell you. And the way they tell the company is usually by talking to their supervisor or possibly a manager, oftentimes somebody with whom they have, a good working relationship. And they'll say, hey, this is what I'm hearing. And what the employer can do in the situation is listen, nod his head, but it's usually a good idea not to ask any questions. Even to make comments can be a little bit risky at this point. But to being an interested and engaged listener is perfectly lawful and, in fact, a really good idea. And then, of course, you want that information filtered back. Now, of course, some of the people telling you this is what's being said or this is what's being done are lying to you. They are going to be saying what the union has suggested that they tell management. And so you have to take what is said with a grain of salt, especially if you're hearing the same thing from five different people and it's almost verbatim. It's a pretty safe bet that the union has planted an idea. And many times what the union will do, and again, this is not a criticism of the union. This is smart on their part. But what they will do is they will try to persuade the company that the union activity is diminishing or isn't very strong. And the reason they do that is that they want the company not to actively campaign against it. So if the company thinks, oh, the union's about to go away, we don't have to invest the money or resources or time into campaigning actively, then perhaps the union will get a jump on the company and the union will continue its campaign. It's a little bit like imagine again that Mary and Bob are running against each other, and Mary hears, well, Bob's about to withdraw. You're going to win in a landslide, so don't worry about it. And Mary decides, oh, okay, I'm not going to campaign as hard. Well, in fact, Bob isn't about to withdraw. He's going to continue his campaigning. and Mary is going to be the one that's going to lose because Bob has been more active than Mary in the campaigning. So you have to take what you hear from your employees with a grain of salt. You also have to realize that even employees who aren't totally in or aren't in the pocket of the union know where the company is, and usually companies are going to be opposing the unionization. And people want their boss to like them, and so they are likely to color what they say in a way that makes them sound like they're more supportive of the company, or make it sound like the company is more likely to win. They're going to tell the supervisors what they think the supervisor wants to hear in many cases. So even employees who aren't intentionally giving bad information, they oftentimes will give information that isn't completely accurate. Another source of bad data is the supervisors oftentimes have a wrong or an overly optimistic view of how the union is viewed, in part because, again, they're hearing from people who are telling the supervisor what they think the supervisor wants to hear. But another part is supervisors always think they're more beloved than they are. I mean, that's just kind of human nature. The supervisor thinks he's doing a great job, and maybe the workers agree. Probably some of the workers agree, but a lot of times people don't like the boss quite as much as the boss thinks that he or she is liked. And so a good rule of thumb that we followed was if the supervisor thinks, let's say, of his 50 workers, only 10 support the union. We always doubled that number. And so if it was 10, it probably really was 20. And so you have to keep in mind that the supervisors are probably going to undercount the union support, in part because they genuinely believe it's lower than it really is. And again, in part, they want to impress their boss because if the number is high, it kind of makes them look not so great, especially in a department that isn't traditionally one that's likely to vote in favor of union activity, because again it suggests maybe they're not the best supervisor if their workers are so pro-union, because oftentimes a vote for the union is really a vote against the supervisor. So you don't ask employees their attitudes, but you look for indications. The supervisor's also noticing who's talking to who. If somebody who ordinarily doesn't isn't super chatty or doesn't mingle is suddenly mingling, that person may be a union supporter who's trying to persuade other people to support the union. And so just noticing traffic patterns and conversation patterns in the workplace can give that information. What you don't want to do is engage in surveillance, though. This is stuff that's happening in the workplace that the supervisor is appropriately observing because people are supposed to be at work. What shouldn't happen is that you shouldn't be surveilling people during their breaks or the lunch hours or before or after work. So that's important that we don't surveil or don't monitor people when they aren't supposed to be working. Um, so the polls again, the employers are going to be polling their supervisors to see what they think the employees are thinking about and how they think the employees will work, but you don't directly poll the employees. Employers can and should regularly state their views regarding unionization. But again, you have to be careful that you've trained your supervisors and managers about how these statements can be made, both how it can be made legally and what are effective ways of saying it. We'll be talking about, or well, actually, let's now talk about union meetings. Um, the employer is also entitled to require employees during their normal workday where they're clocked in to attend union meetings where information about unions are shared. There's a lot of misinformation and lack of information about how unions work. And so this communication is really, really important for workers who may not understand what right to work means. In fact, some workers think, well, I'm in a right to work state, so that means that the union won't affect me if it gets voted in. Completely untrue. It is true that in a right to work state, the employee can't be forced to join the union. But if the employee chooses not to join the union, it doesn't mean that if the union comes in, that the union won't dictate the terms and conditions of employment for all the workers in the bargaining unit, whether that worker is a member of the union or not. So that employee's wages and terms and conditions will be completely controlled by that negotiation between the union and the employer. And that worker who chose not to join the union won't have a voice in that process. So you can see how the employee, whether you're in a right to work state or not, is going to be hugely impacted for the good or for the bad. It can go either way, obviously, by the addition of the union to the workplace. And so communicating that to employees is really, really important because if you don't communicate that clearly to the employees, many pro company employees will choose not to vote. They don't want to get involved. Some of their friends are pro union. They just want to sit this out because they don't want to have a controversy. Perfectly understandable, but not in that employee's long term interest. Employers can require attendance at the meeting, but they can't require that employees vote a certain way or vote or choose not to vote at all or things along those lines. They can't give promises of better conditions. They can't threaten about worse conditions under those circumstances. The best communications that employers can do during this meeting is factual communication. Yes, you can do some campaigning or things along those lines, but it's best to stick to the facts. And obviously, these facts have to be true facts. One some common topics for the meetings are number one, to explain what a union is, how a union gets its money through the dues, what the election process is going to look like, what the collective bargaining process is going to look like. One important idea is that there are no guarantees. The collective bargaining agreement, if one is reached, and there's no guarantee of that, the conditions in the workplace may be better or maybe not as good. It has happened both ways. It can happen both ways. And the employee needs to be aware that it's not a situation in which, oh, well, we have a certain level of benefits right now, certain level of wages, and the collective bargaining agreement lawfully has to give us more. Many times unions will say that. And again, they're allowed to say that because the assumption that the NLRB has is workers are sophisticated to know enough that the union can't promise that. And so when they say that, the employees are supposed to be savvy enough to know, oh, that's just talk. That can't really be guaranteed. Um, but the reality is there are workers out there that genuinely believe the union when the union says that. And so the employer has to go in and say, wait a second, that can happen. Wages can go up, wages can also go down. Working conditions can improve, absolutely. Working conditions can get worse. Both of those things can happen, has happened. We don't know what's going to happen, and the union doesn't know what's going to happen. Nobody knows what's going to happen because we haven't negotiated the contract yet. Um, so the employer is educating unsophisticated employees about the unionization and the collective bargaining process. The employers are also usually educating employees about the benefits that they enjoy, and so explains both what the benefits are and how those benefits are established. Now, this is one of the things that smart employers have prepped their employees for this before the union was even on the scene. And there's two big ways that employers engage in union avoidance from day one. The first is making sure that their wages and working conditions are competitive in the market, and especially competitive with employers in the region that are unionized. So the employers can say, look, down the street a Teamster plant exists in our same industry. Here are the wages they earn. Here are the wages we earn. They pay 2 hours a month of their wages to the union. You pay 0 hours a month of your wages to the union. Who has the better deal? Again, you're hoping that your wages are at least as high as the Teamsters or whatever the union is, and in a perfect world, be even higher. Um, and so that requires that you've thought about these issues long before the union has arrived. So you have a very powerful story about how good things are here. And of course, you compare them to the competition. A lot of employees don't shop the market and don't know what other employers are paying in the area, but you can get that data and present it. And you don't say, some employer, you're very specific. This is what, Bob's Grocery down the street pays its workers. This is what Mary's Grocery down the street pays its workers. This is what we pay. You also want to make sure, so you want to make sure your wages and benefits are competitive. You also want to make sure that your employees know what all the benefits are to which they are entitled. And you want that communication to happen long before the union is even a topic of discussion. Number one, you want them to know about that so that they can participate in those benefits, so that they can get the things that they're entitled to, but also because it can be a powerful source of information so that when the union comes, the worker already has a good sense that they have a good place to work already. So these union meetings are an opportunity to tell those stories in even more detail. Again, this is assuming that it's a good story. Employers who are caught unawares may find that they aren't paying competitively. And during a union campaign, employers can't change wages or benefits. They're stuck with whatever those wage and benefits are. And so if it happens that the Teamster facility down the street does pay more, that's a bad fact. The union is definitely going to be telling the employees that bad fact. So it's not like the employees aren't going to know what's going on when the fact is good for the union. So what can the employer do under those circumstances? Well, honestly, not a lot. One thing the employer can do is that if there's a reason for the pay differential, the employer can share that story. For example, it may be that the employer pays a lower wage rate but provides better benefits or some other reason that the employee might still be in a better position. For example, maybe the employer can say, yes, we pay lower wages, but we haven't had a layoff like that facility has. And so it's better to have some pay than no pay at all, right? If the number is lower, another thing the employer can say is, well, we've faced, bad economic times that that particular company hasn't faced. And so, a company can't pay more than it's got money. You can't get blood out of a turnip, and you can't get more money out of an employer in terms of wages than the employer has available. And so there are some messages that can happen when the employer isn't competitive, but that makes the union campaign much, much more difficult and much more likely that the union will be successful. And that makes sense. The union can show that it has delivered to workers in another facility. If I'm the employee, I'm going to find that pretty powerful. Another thing that the employer is going to talk about is the union itself. The employer is going to be able to get certain documents from the Department of Labor that is going to show various required government uh, documents that the union has to file indicating how the union is handling its money and what its connections are to other unions and other relationships. And this information, in some cases, can show that its union officials are being paid very high salaries, for example. It can sometimes show that this union is connected to other locals that may have a bad reputation in the community. The employer can also show times where the union has lost elections and where there have been decertification campaigns because the union was perceived by at least some of the workers to not be a good working partner with them. And so this type of information can be really, really powerful to workers because many times the choice of unionization isn't are you in favor of unionization or are you against unionization? But instead, it's about with this particular employer and with this particular union, and at this particular time, is a union a good deal for you? You might be generally in favor. The employee might be generally in favor of unions, but oppose this particular union, or might be generally in favor of unions, but feel like this employer is a good one, and that a union wouldn't help this particular employee in this particular situation. And so an employer typically wants to unpack that and not make it a general discussion about unions, but make it more specific to this particular situation. Another thing that the employer will talk about is how the law works. And that is, it's very, 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 very difficult for a employee group to evict a union. Once it's voted in, that union will likely be there forever until that facility closes, hopefully in the distant future, because it's very difficult to have a decertification election. So, an employee who may be not thrilled with their current supervisor right now might be tempted to vote in favor of a union, but maybe that supervisor will be gone in 6 months or a year. Well, guess what? The union won't be gone in 6 months or a year, and so it's really a long term choice for maybe what is a short term issue. And just a little information about decertification elections. In some senses, they're similar to the original election. The same bargaining unit exists, the same people are eligible to vote. It's also a majority of those who vote. But the workers themselves have to get in order to have the decertification election, the workers themselves have to get other workers to sign for the decertification petition. The employer can't assist in any way. The union obviously is concerned that it's going to lose its membership. It's going to lose those dues from the people who are members of the union. And so it's working against the decertification campaign. But there's not the balance of the employer working in favor of the decertification campaign. So it's really, really, really hard to have a decertification election where the union is voted out. It just almost doesn't happen. So as a result, once the union is voted in, that's going to be the deal pretty much forever. And once employees understand that, they have a deeper understanding that, hey, wait a second, this is a major, major decision. Now, the union's not going to give them that information for obvious reasons. So it depends upon the employer communicating that information. So these meetings, and usually there's going to be about two or three during the course of that 30-day campaign that happens after the date of the election is announced and before the actual vote happens. Um, and so these are the types of things that are covered. Now, typically, the attorneys and paralegals don't actually um, deliver these meetings. It's much more effective if the managers and the supervisors conduct these meetings. And so the attorneys and paralegals are coming up with the communication tools, the topics, the bulletin boards, the PowerPoints, and training the people who are going to conduct the meeting about how to conduct it. And obviously, a large part of these meetings are the Q and A's, and the pro-union folks will be there too, and they will have questions that are designed to tell the union side of the story. And so, there's the potential for emotions to run high and for uh, people to perhaps say things they don't mean in the heat of the moment. And so there needs to be a lot of training and rehearsal to make that effective. You typically want people to conduct these meetings who are generally popular with employees, who are articulate, can speak, and can keep their cool, um, and also people that have a leadership role. You may want to have some supervisors have this role, but everybody understands where the buck stops, who the big bosses are. And it's useful to have those folks there, not only because the employees will expect to see them, but also it communicates that this is something the employer sees as a really important issue. And by hearing from the muckety mucks in the facility, it communicates that the employers is really focused on addressing these issues. Now, of course, what can't happen at these meetings is or what will happen at these meetings, but is that employees will share grievances. I don't like my supervisor. He plays favorites. I never get to blah 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 blah, but Bob gets to blah 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 blah. You'll hear tons of those in these meetings. And one thing that the employer can't do is can't solve the problem. Can't say, oh, we'll fix that. Because again, that is during a campaign, we have to have those laboratory conditions. So you can't just say, well, we'll fix this problem, we'll fix this problem. What you can do is you can listen carefully and say, thank you for sharing your concerns. We take all concerns seriously. Thank you so much. We have heard you. And that can be a way of communicating um, that uh, we are now aware of this issue if we weren't before. And the employee will hopefully not expect things to change in this situation. Again, in the meeting, you're likely to say, we can't make changes now. That's not permitted under the law. So let's see what additional rules are about what employers can do during a union campaign. Again, we're looking on the employer side. Obviously, employers cannot discharge or discriminate against pro union employees. You can't terminate them, you can't demote them, you can't reduce their hours, you can't make them work less pleasant shifts, you can't tell them that they can't talk to other workers. You have to treat them the same way you treat any other worker. And you don't want to do any of those things, number one, because it's an unfair labor practice. But you also don't want to because if you do that kind of stuff, the other workers are going to say, wait a second, that's not right. I need some protection from an employer that would engage in this way. And many times that can, if you do something that is perceived that way, you can actually cause more employees to support the union than otherwise would have. And so the employer has to be careful not to engage in these behaviors, but also not to appear to engage in these behaviors. So my experience is that many times pro union employees will actually try to bait the supervisor a bit because they want to do a couple of things. Number one, they kind of hope they do get written up so that they can tell the other workers, look, I'm pro union, they're retaliating against me. They also may want to file an unfair labor practice charge against the employer and talk about that to the workers. And of course, if they don't have any ammunition to use, they're not going to be able to do that. They also like to do that kind of stuff because even if they're not disciplined, then they can turn around and say to the workers, look, when even the threat of a union is around, you see how the employer kind of caves into us. Usually I would have been written up for doing that, but I wasn't written up because the company is afraid of the union. Think how much better things will be here once the union actually is here. Right now it's not here, and the company is already treating us better. Just think about how much better it'll be when the union actually is here. So there are lots of reasons why the union pro-union employees may bait supervisors and managers, and of course this needs to be covered, and those managers and supervisors need to be trained about how to handle that, how to keep their cool, how to make sure they are not discharging or discriminating against those workers. We already said that the employers have to allow the employees to talk among themselves. Um, at work, but obviously during non working time. If it becomes a huge disruption to the working environment, then the employer can address that. Again, has to be handled very, very carefully so it doesn't look like retaliation. But certainly during breaks and lunches and before and after work, there should be no monitoring of employees. The employees should be free to have these conversations when they want to. Again, keep in mind, there will be people who are pro company who will be talking about how bad the union is. So it's not necessarily a bad thing for the employer to have these conversations occur. And again, as we said, the employee should be permitted to wear union buttons and to go to union rallies or meetings if that's what they wanted to use. Similarly, employees can have anti-union buttons and to have anti-union rallies if they want to. Employers don't have to allow non-employee organizers to have access to inside the facility. Now, where in terms of parking lot access or things like that, generally speaking, employers can also preclude that. How strictly an employer wants to follow, or the parking lot limitations is going to vary depending upon circumstances. There are some cases wherein if the union really doesn't have any way of getting access to the employees except by having some very limited access to the parking lot, the union has been found to have that right. If there is a safe place, a public right of way, um, maybe a little road leading to the facility where the union organizers can congregate, then the company can preclude the union from being on the facility. Uh, and so there's going to be some judgment calls in those areas. Again, you're going to want to have a lot of legal research before you make a decision about exactly how you're going to handle that circumstance. But there is no need to give the union equal time or have meetings where the union is also there. Employers are not required to do that at all. Keep in mind the union will be having meetings, probably a lot more meetings than the employer has with workers. The difference is that it will be outside of normal working hours and that employees aren't required to attend. Often, other differences will be oftentimes these meetings will involve, pizza and beer and also kind of a festive party environment, which probably the employer meeting won't necessarily communicate. During a union organizing campaign, an employer is prohibited from trying to help employees to form kind of a competing union. Employees sometimes do choose to form their own union and not be part of a larger organization, such as the laborers or the Teamsters or something like that. But that has to be an employee only activity. If the employer is involved in forming it, it's called an employer controlled union, which is not lawful. So here are some things to think about. Some of these I've already covered with respect to union avoidance. Union avoidance isn't something that begins when you first hear about the union being interested. It is something you start from day one. You're educating employees from day one about unions. Um, in many of my facilities, literally on day one, employees would see a video that explained how unions work. You're constantly evaluating the morale of employees. When morale is low, then you know you're at more risk for unionization. You're also trying to avoid having those types of favoritism or other problems by actively seeking feedback from employees about what the company is doing well and what the company isn't doing well. But also, a lot of this is informal. The supervisor should be listening to see, oh gosh, nobody likes Supervisor Bob. Maybe we need to talk with him and get him on board with how to handle people better, how to work with people better. Maybe he needs more training. Maybe he needs to be fired if he's sufficiently not so good. Maybe he needs to be moved to a different part of the facility where his personality is a better fit. So part of this is letting the employees know or letting the employees see that the company will do the right thing. And the way you do this is by doing the right thing consistently. No company does the right thing every time, but having that track record and documenting it so you can tell that story to employees. Hey, remember 2 years ago when we had that supervisor, Bob? Well, as soon as we figured out he wasn't treating employees fairly, he stopped working here, didn't he? And remember the other time when Supervisor Sally was treating employees inconsistently? Well, remember how suddenly that stopped and she started treating employees consistently? We fix things when we know about them. And when you can tell during the employee meetings that story, it's really powerful. So do the right thing. Don't just tell people you're doing the right thing, but do it every day and communicate about that. Not just during the union campaign, but all the time. Let the people know that there is this pipeline, a way to get problems solved. And constantly be aware of this issue. Have it be in the front of people's minds of managers and supervisors that this is a priority for the company and to brainstorm about how to increase and strengthen the union avoidance approach over time. So this is a shorthand way of remembering it. This is what all supervisors and facilities that may be unionized are told, this little mnemonic, TIPS. And it stands for the things you can't do during a union campaign. You can't threaten workers. You can't say, if you vote for the union, the company will close this facility. That's an unlawful thing. Or if you vote the union in, that there's no way the company will uh, raise wages through the collective bargaining process. All of those would be considered threats. You can't interrogate or question workers. Again, you can listen actively, hmm, hmm, you know, but you can't ask questions of workers about what's going on in the union area. Just like you can't threaten, you can't make promises. Things like, boy, if this union goes away, I'm pretty sure we're all going to get a big raise. So you can't do the flip side. You might call this like extortion and this is a bribe. You can't do either during a union campaign. And you can't survey people. You can't monitor people. You can't spy on people. So, if you have cameras on outside the facility, you have to turn those off when there's a union campaign if those cameras would catch um, the hand billing or the spreading of brochures. So you won't have a record of who picked up a copy of the brochure and who didn't pick up a copy of the brochure. All these are really important things that need to be drilled into people's heads, the supervisors and managers, repeated constantly. Um, the union folks will know that these things are unlawful, so they will be listening for anything that gets close to the line. And they may, human nature is human nature, exaggerate what was said. So you don't want anything even close to this line so that it can't be distorted or misinterpreted um, in a way that might be a ULP. And these would be all ULPs for sure, unfair labor practices. So let's talk about some common union organizing techniques. One thing that unions often do is say, look, we've got over 50% having filled out authorization cards. We want you to recognize us right now and just avoid the whole union election. Um, the vast majority of employers will not accept this idea. There are a few that are already largely organized by unions who have agreed to what's called a card check, where the process is that once you're largely unionized, the downside of being more unionized isn't that significant, and in fact, in some respects, it may make life easier for the management under those situations. So that's one thing that the union very possibly will consider doing if they think there's any chance of success, but the company in most cases will say no. The union will visit people's homes and will try to organize people into groups. Many times these are called kind of cells, designed to create a sense of family. That these are some people that I know that are supporting me, that are on my side, and they're also associated with the union. These home visits can be awesome and wonderful for employees. They can also be perceived of as intimidating to employees if people knock on their door, oh, they know where I live. And so sometimes the home visits can backfire for the union. Sometimes they can intimidate in a successful way, and sometimes they can be very positive for the employees. The employers don't do home visits. Let's talk about union salts. This is an important topic. These are people who are supporters of the union, maybe even employees of the union, who have applied to work for the employer. And many times they are coming to work uh, for the sole purpose of talking up the union and having an inside voice to the union so that they can have access to employees during breaks and lunches. And sometimes even the employees themselves don't know this is a union salt, that this is somebody who really works for the union. They just think this is somebody who's pro union. And of course, this person is not focused on necessarily doing a great job at the place of employment. And they're probably not planning on remaining employed here for very long, but they're focused on encouraging people to join the union. So they're likely to be very outgoing, social people, charming people that can attract other people to their sides. So when an employer thinks that somebody is a union salt, the employer is very likely going to say, wait a second, we've got, a spy in our midst, and they will be inclined to want to fire the person. But the current law is you can't fire somebody who is a union salt. You can fire them if they're doing a bad job, but you can't fire them simply because they are here for an ulterior purpose. So if the union salt is performing satisfactorily and isn't violating major rules, then they can continue being a salt. Sometimes an employer will see an application that appears to be from a union salt. There are certain indications on the resume that really suggest that this person is a salt. Under those circumstances, the employer can't decide not to hire the person simply because the employer suspects this person is assault. Now, many times assault will not be the best candidate because, again, he or she will have spotty employment, moving from one place of employment to another, or that person may not have the skill set. You don't have to hire assault who isn't the best candidate for the job, but the fact that this person is assault can either make or can't preclude that person from being hired. Um, we've already talked about the social events, the happy hours, the events like that, which may or may not include alcohol and food. And again, this can be a way of making the employee feel like he or she is a part of this larger group. Who doesn't want to be a part of something fun and social? And it can also make the employee feel just a little bit socially obligated. Well, I drank their beer. I guess I owe them a vote, that type of idea. So, those are important strategies that the union has to persuade employees to join the union and also to vote in favor of the union. The union may invite the employer to debate. The a union again that's helpful to the union. Obviously, the union may have better debaters than the employer, so that's helpful. Another thing is that it creates in employees' minds the idea that the union and the employer are kind of equal in authority or equal in power, and which obviously involves the union kind of being elevated. It's a little bit like if Bob is a severe underdog in a campaign for, say, senator, and Mary is a strong favorite. Well, Bob wants to debate Mary because that's going to increase his access to voters and is going to cause some voters who perhaps were thinking about Mary to consider Bob. Mary, though, doesn't have a lot of reason to agree to the debate because she's already winning. And anytime that Bob gets more airtime, it increases the odds that that might flip and maybe Bob will get some more support. So employers almost always say no to the idea of a debate. Just like employers use hand billing, unions can use hand billing. And when I say hand billing, this is the passing out of brochures. Uh, and they can also do informational picketing sometimes. We'll talk more about informational picketing later on when we get to the picketing section. The union oftentimes will uh, do actions to rally behind employees, help the employee file an unfair labor practice, communicate to other employees what's happening. They may even extend some kind of benefits to employees who have been fired because of their union support, or at least that's the story they're telling. May be true, may not be true. And so that can make the other workers feel, wait a second, the union's on our side, the union's going to protect us. So those are other strategies that can be helpful in persuading companies to, unions to um, techniques to win the union election. So here are some common topics that can make a company more likely to be subject to a union campaign. When people feel their jobs are insecure, many times they look to unions. They have the feeling, which is sometimes true and sometimes false, that having a union will create additional job security. Of course, the reality is that many heavily unionized industries have lost lots of employment opportunities. The textile industry, the steel industry being two big examples, because a union can't change the underlying economics. But the union can certainly cause um, the way that layoffs happen to change through a collective bargaining agreement, assuming it's agreed upon by the company. And so it certainly is true that certain aspects of job security can definitely change with a union. This is a huge one, capricious treatment by management or supervision. When supervisors don't act consistently, don't act fairly, this is probably the single biggest threat that the company will have to a successful union campaign. The idea is that the union will be able to counterbalance unfair treatment by supervisors. In some instances, that can happen. Sometimes the union is the capricious part of the equation, and because obviously people are people, and supervisors can be unfair, managers can be unfair, shop stewards can be unfair. That's part of, unfortunately, the human experience. But certainly, an employer that has unfair management and supervision is much more likely to be subject to union campaigns. Arrogant, hostile, abusive management. This is somewhat similar to the one we just mentioned, but management that are jerks. Oftentimes, the feeling of the employees will be, we're going to show them we have some power. They're going to have to deal with the union. So it may almost be a retaliation against those managers. Hey, we don't want the union either, but we know you really don't want the union. And so we're going to vote the union in, that type of idea. Incompetence. If the supervisor doesn't know what he or she is doing, that can be very frustrating in the workplace. Now, one thing about unions is that unions don't get to decide who the managers and supervisors are. That is something that the employer gets to decide. So the union may be able, through a collective bargaining agreement, change the rules that are followed, but the identity of the managers and supervisors isn't going to change when the union comes into effect. So the union isn't going to be able to insist that the supervisor be replaced. I mean, they can say that, but they have no ability to affect that. And the union can't train the supervisor. So some of these concerns, even though they are oftentimes the focus of the union campaigns, are actually areas that the unions don't have a tremendous amount of control. The union can't force people not to be arrogant. Now, the treatment aspects of the collective bargaining agreement does provide for certain procedures that can change, um, but the personalities of management supervision isn't something the unions are going to be able to change. If the compensation and benefit package isn't fair, this is a big area that the unions can step in. Now, this is probably one of the most um, reasonable areas. If I were an employee in a facility that was considering unionization, this is one of the most powerful arguments that would exist for me, because this is one that the unions can actually change significantly. The other one's not so much, but this one they can, because it can be subject to the collective bargaining agreement. So if there are unfairnesses, um, the union can advocate strongly for that during negotiations. Now, of course, the employer is going to have to agree to any changes to the package. So it's not a guaranteed situation that if you vote the union in, you're going to get more money. But it certainly can be a very important part to the union position for negotiation. Occupational workplace safety concerns, again, another area where these can oftentimes be addressed through the collective bargaining agreement. Fairness issues related to job status. Um, in terms of, certain people in certain departments are treated better than people in other departments. This is a mixed bag, because the union isn't going to be able to address differences between salaried and hourly employees, because the salaried employees aren't going to be part of the bargaining unit. So, but differences between hourly departments, when all of the departments are part of the uh, bargaining unit and therefore under the same collective bargaining agreement, can be addressed. Now, they can be addressed, but keep in mind that if one group of people feels that they're being treated better and another group feels they're being treated less well, the ones who are being treated better are going to vote against the union, obviously, because they recognize, wait a second, the union comes in, they're going to take away this perk that I have. And so fairness issues can sometimes work against the union, sometimes work in favor of the union. uh, uh, Longevity, which is usually called seniority, is a big issue. Are people who have longer service being recognized in the organization in terms of higher pay, um, more opportunities to get higher positions? That is one of the things that unions usually advocate strongly for, and most collective bargaining agreements do include those provisions. That's one of the reasons why, back when the employer is trying to create those union avoidance techniques, is that emphasis upon seniority, is a big thing. Um, Again, when I was practicing union avoidance, we had the same seniority rules that unionized facilities had. So when you posted into a job or when you applied for a promotion, and we had public job postings, seniority was the single most important factor. You had to have the skills required for the job, and you had to be performing satisfactorily in your current job. But assuming those two things were satisfied, you were the one that was going to get the promotion. And so in this facility, many of the facilities in which I worked or supported, we had very long service people. So you'd have people that had been there 25 years, and then somebody with 26 years would get the promotion. So the person with 25 years was too much of a new hire, so to speak. You might have situations where a person with 12 years who's an awesome worker doesn't get the job that the person with 13 years who's, okay, but not great worker gets the job because he has more seniority. That actually can create moral problems as well. But the union isn't going to address those type of problems because the union is going to definitely value or want to value seniority pretty much over anything else. And so usually employers trying to avoid unionization also emphasize seniority. Lack of promotional opportunities. Again, this isn't something that the union is really going to be able to address, but it can be a source of topics that the union will want to talk about. The union can't create new positions within the organization. Discriminatory personnel practices. And again, this is another area. This is the one that ties with all the stuff we've been talking about before. If there is racism or sexism or other types of isms out there, especially when the management is perpetrating those types of behaviors, those give the union a lot of material to work with. And so you want to make sure that these issues are being addressed and that there aren't problems in these areas in your workforce if you want to avoid the union. And if, of course, if you're working for the union, you're going to want to talk about all of these items, both on your one-on-one meetings, in your group meetings, and also in your handbills that you distribute to workers. Okay, so let's talk about what that election actually looks like. Uh, the procedures are established in the National Labor Relations Act for how these representation elections will proceed. If the employee is part of that community of interest, that bargaining unit, then he or she will be eligible to vote. He or she is not required to vote, but if he or she votes, uh, then however many people vote, again, I covered this before, but let's say there's 1,000 people in, or we'll say 100 people in the unit, 70 vote. Well, the union is going to need 36 to vote in favor of it, and in order to prevail. Typically, the employer wants a high turnout because the 30 who didn't vote were probably company votes. Um, so the employer is going to make it as easy as possible for as many of the employees to vote as possible. The employer can't require that employees vote, but certainly the employer is going to work very hard to make this number be as large as possible. But whatever this number, let's say this number is 90, well then you would need 46 votes for the union to win the election. So this is going back to the authorization cards. Here's an important vocabulary term. You'll definitely want this for your Quizlet as well as decertification. Oftentimes these are called decert elections. People won't say the whole word, but decertification is the complete term. So again, for authorization cards are the path to the election. They are also a tool that the union does to get support because the idea that happens is once an employee signs an authorization card, he or she is going to feel a little bit, or sometimes he or she will feel a little bit like he or she has made a promise to support the union. And so they may kind of feel almost honor bound, especially after they've eaten the food and drank the beer or whatever, to go ahead and vote for the union. And so this is a tool to kind of emotionally connect the worker with the union. So the union can't request the election of the NLRB until at least 30% have submitted to the union these authorization cards. But as I said before, usually they wait until it's more than half because they don't want to lose an election. An election is expensive for a union, both in terms of time and money, but also in terms of its prestige in the community. So if it orders or requests files for an election, and when it only had 30% of the vote not locked down, number one, it's likely to lose because some of those 30% aren't even going to vote for it. So they could have 30% and then turn around and only get 10% of the vote when it comes time for the election. It doesn't make sense for a union to attempt an election unless it feels like it has a pretty decent chance of winning. The term that you say for the union is that it becomes the exclusive bargaining representative or the exclusive representative for all the employees in that bargaining unit. So I probably should add the word bargaining here. It may be the whole facility. It may even be more than one facility. I'm not going to write the whole word, but I mean bargaining here. Or it could be a portion of the facility. We already talked about the decertification and how very unlikely it is. And again, there is the possibility of voluntary recognition of a union. Employers typically do not do that unless they're already highly unionized. We already talked about the card check procedure. And sometimes unions, or excuse me, employers that are already heavily organized will have in their contracts a neutrality agreement where the employer promises not to campaign against the union. Now, the employer can't be supportive of the union. That is not a lawful option. So the employer can't say to its employees, we recommend you vote in favor of the union. That's not lawful. The employer can recommend a vote against the union, or it can say neutral. We're out of this. This is your decision to make. And so we have these additional vocabulary terms to be adding to Quizlet. So representation by a union is distinct from membership. So again, in a right to work state, you may not be a member of the union, you may not be paying union dues, you may not get a vote in union elections, but you are still represented by the union if you work in the union bargaining unit, and your employment will still be controlled by that collective bargaining agreement, a document that you had no voice in its creation. Okay, so let's talk about union security provisions. So now we're going to talk about right to work in more detail. So we have two choices. About half the states are union security states, and half the states are right to work states. Texas is a right to work state. You do need to know this for the test for sure. And if you're a right to work state, you can't, Texas, it would be unlawful to have a union security provision in your contract. Typically, states in the South are in the southern part of the country are right to work states, and more northern states are usually union security states. And generally, union security states are the states that have more union activity, probably for pretty self evident reasons. So, what is the difference, right to work? Before we begin, let me just make this clear. Right to work has nothing to do with at will employment. This is one of the most common points of confusion that I see for folks, that they think right to work means the same thing as at will employment. They have nothing to do with each other. You can have at will employment and be right to work. You can have at will employment and be a union security state. In fact, all states other than Montana are at will employment states. So, you know, almost, states that are union security states are also at will. You can have states that aren't at will. I don't know what Montana is, but you can imagine a state who decides not to have the at will employment doctrine anymore. You could imagine that state still being right to work. You can imagine that state being a union security state. So let me remind you what at will employment is. At will employment means that the employee can quit his or her job at any time for any reason without any notice. At will employment from the perspective of the employer means the employer can end the employment at any time with or without notice for any reason other than an unlawful reason. Now, I think the reason that people get at will employment confused with right to work is that most collective bargaining agreements are provide uh, additional requirements for when the employer can dismiss the employee. So the collective bargaining agreement removes that at will employment circumstance. Not all collective bargaining agreements do that, but the vast majority do. So if the collective bargaining agreement is agreed to by the employer and ratified by the union, then the employees, assuming this is the language in the agreement, the employees will no longer be employed at will. They can still leave employment whenever they want to. That's not going to change. But the employer isn't going to be able to dismiss employment for any reason. There will be only the reasons provided for in the collective bargaining agreement. But until the collective bargaining agreement is signed, that is, the employees are still going to be at will. And there are some collective bargaining agreements that still contain at will language. So even with collective bargaining agreement, it's not guaranteed there won't be at will employment. Okay, so I've explained again what at will employment is. Let's talk about what right to work is. First of all, let's talk about the reverse, which is the union security version. So, the first thing to keep in mind, even in union security states, the workers uh, um, are still right to work in terms of their particular unit until there's a collective bargaining agreement. So nothing changes the day after the election when the union is voted in. The employees don't have to join the union on that next day. And in fact, the union usually doesn't even, you know, uh, try to force or try to I don't say force, that's not the right word because that would not be lawful, but the union isn't focused on collecting union dues until after the collective bargaining agreement goes into effect in many cases, because the union isn't able to provide benefits to the employees at the time, and the union recognizes that it won't be able to kind of deliver things of real value to the employees. And so it recognizes the employees aren't going to probably want to pay union dues. Moreover, the employer isn't going to assist the union in collecting the dues. So the union is going to have a relatively difficult time persuading the employees to part with their money because there won't be an automatic payroll deduction in those cases. But let's fast forward in a union security state, again, not Texas, but another state, we'll say Wisconsin. The union and the employer negotiate a collective bargaining agreement. One of those provisions in the agreement could be a union security provision. It doesn't have to be in the contract. You can be in a union security state and have a collective bargaining agreement that does not contain a union security clause. It's just a lawful clause to have. So you can have it in these states without violating the law. So in those states, the union can negotiate over having a union security clause in it. Let's say the employer also agrees to that clause being in it, and the collective bargaining agreement is reached, and the union votes to ratify the collective bargaining agreement. Well, at that time, the collective bargaining agreement is in force, and the union security clause kicks in, and that requires that everyone who is in the bargaining unit has to join the union and pay union dues by a certain date. If an employee says, I'm not joining the union and or I'm not paying union dues, then that employee can no longer work in that collective bargaining unit during, once that deadline comes. I mean, they could apply for a job in a part of the facility that isn't part of the collective bargaining unit, or they could join supervision or management. Those would be fine. So they might still be able to work for the employer, but they can't work in the collective bargaining agreement if there's a union security clause. Um, so this is different. Union security clause is different than a closed shop. A closed shop occurs when the union gets to veto or tell the employer who to hire. In a union security situation, the employer is still deciding who to hire. The union doesn't have any veto over that. The union can't say, don't hire Bob. No, that would be a closed shop, which is unlawful. You cannot do that. But a union security clause can be the company chooses to hire Bob. There's a union security provision in the collective bargaining agreement. The union might not want Bob to be there, but the union has to take Bob. But Bob is going to have to join the union. The union can't say no, Bob. The union has to accept Bob, but Bob does have to pay union dues. So that's the difference between closed shop, which is unlawful, and a union shop. So how does right to work work? Well, in a right to work state, that union security provision is unlawful. Even if both the employer and the union want to include that in the collective bargaining agreement, it can't be in the agreement. So let's say, again, the union and the employer negotiate a collective bargaining agreement, and it is ratified by the union, and so it goes into effect. We're in a right to work state, so there is no union security provision. So employees don't have to join the union. The employees don't have to pay union dues. Now, if they don't join the union, they're not going to have the opportunity to vote on the collective bargaining agreement. They're not going to have a vote or a voice in deciding what the priorities are for the collective bargaining agreement. They aren't going to be able to become a shop steward. But even though they're not joining the union is still lawfully required to represent their interests. So if I choose not to join the union, but I have a grievance, my supervisor violated the terms of the collective bargaining agreement, and I want to file a grievance against my supervisor, I am entitled to follow the same process, the union process that a union member would have. And the union is supposed to treat me exactly the same way that it would treat a union member. And you can see right away this creates what's called in the law a free rider problem. And we'll talk more about this later, but this is the problem. Probably actually have it on the next slide. Let me see if it is. No, I don't. Okay. The free rider problem um, arises by that worker who doesn't join the union, doesn't pay union dues, but he gets the benefits of the union contract. So the idea is, why would anybody join the union? I can get the advantages of the union without paying typically what's about if I earn say $20 an hour, that would typically be about $40 a month I would pay. You know, the due structures can vary. That's the one that I've seen most commonly with the Teamsters and the laborers, but other unions have other some for some unions it's a flat fee, $15 a month. Some unions it's based upon the hourly wages. But whatever the system is, you can see the temptation. I get the advantages of union membership, but I don't have to pay for it. And so that's the free rider problem. You know, who's going to pay to ride a bus when you can ride the bus for free, right? That's the idea. And so that's the reason why unions look to union security clauses. They prefer to organize in states where they can require people join, because after all, unions have expenses. They've got to keep the lights on in their buildings. They've got to have staff, secretaries, business agents, other people who organize workers, who negotiate the contracts, who have the expertise. Those cost money. And so, if they don't have people paying, they aren't going to continue to exist as an organization. Their source of revenue are union dues, just like when Ford Motor Company, its source of revenue is selling cars. And a law firm, its source of revenue is the the hours that attorneys and paralegals bill. Well, the source of revenue for unions are those dues. So you can see the problem. Now, the argument that unions advance to persuade people to join in right to work states are, you get a voice. You get to, tell us what you're concerned about. So we'll consider that when we negotiate the contract, and you get to vote whether to ratify the contract. You also get to vote on whether we're going to strike or not. And you get to vote on who the union leadership is, who the president and vice president and treasurer are, those types of positions. Um, Also, sometimes implicit in it is the idea of, uh, you know, maybe you'll get treated a little bit better by the union when you have grievances if you're a dues paying member. But again, that's not a lawful consideration in making that decision. Okay, so those are the differences. Here I have a little bit of granularity about union steward. I presented this term as a definition earlier, but this may be one that you also want to include. So a union steward is going to, and this is a union steward's going to exist in right to work states and union security states. This is someone who is an employee of the employer and also a union member, a person in a leadership position. Unions usually like to get someone in this position who is liked and respected by his or her coworkers, who's been around the facility for a while, who kind of knows how things happen. Anyway, this person it may be involved in collecting dues, recruiting new workers, um, and is usually the first person who receives grievances and assists in the processing of those grievances. In many workplaces, these people may have reduced or no active work responsibilities um, in the employers. That may be a defined position through the collective bargaining agreement for a larger employer. Okay, so now at this point, we've discussed the history of unionization. We've given an overview of the first or the original part of the NLRA, the Wagner Act, and we've talked about union campaigns and elections. Now let's talk about collective bargaining. And I've kind of talked about a lot of this, so some of this I'll probably go over pretty quickly. So collective bargaining is that process by which the union that's been designated the exclusive representative of the workers in the um, bargaining unit and the company sit down together and they hash out and negotiate just like in a normal contract negotiation. The union has priorities, the company has priorities, things that both want to accomplish through this. And many times the union, in fact, I say usually the union has employees involved in the process. That is a way to get employees excited about union membership and also to spread out the work because this negotiating process is likely to take tens of hours, maybe even more than that. It is really a pretty significant time commitment for all parties involved. Both parties have to negotiate in good faith. Now, what this means is a little bit tricky. Both parties have to come to the table intending to try to reach an agreement. That has to be their goal. They have to sincerely attempt to work through the issues that are in play, that are on the table, so to speak. They have to actively negotiate about all mandatory topics. They don't have to negotiate about permissive topics, but they can if they wish to. We'll go through some examples of that in a later slide. But neither side has to give up any point that they want to. So let's say workers in a particular facility earn $15 an hour. The employer can say, we've arrived at this $15 an hour by doing market surveys, by seeing our profitability of our industry, and we feel that this is a good wage. And so we want to stay at $15 an hour. The union might come back and say, we feel like, or we insist that our workers earn $17 an hour, and this is how we arrived at this figure. Maybe some employers earn a little bit more, whatever. And so they both come in with these numbers. Neither side has to change their numbers. They need to explain how they arrived at that number and provide supporting data. But if that's what they think the right number is, they can stay there. So it's not a situation where, well, the employer has to offer 16 or the union has to agree to 16, halfway in between the numbers. The union can absolutely still negotiate in good faith and stay at its original number. The company can absolutely negotiate in good faith and stay at its original number. Now, I will tell you that probably both will do this instead. But the company will say, well, having a union around is going to be more expensive for us. So we're going to have to drop people's wages to $14 an hour. And then the union might say, well, we really think $18 an hour is where we think the pay ought to be. Now, both recognize that this gives them room to negotiate. So the company is saying 14, but they probably have it in their heads, we're willing to go up to 15. The union may start at 18, but they know we're probably going to have to drop to at least 17. And one of the things that has happened by changing from the original number is that they have also created the appearance and hopefully the reality that they are negotiating in good faith. So typically, you will see numbers move closer together, even if they don't actually reach a final agreement as to what the wages will be. They remain there remains a gap. By increasing their numbers over time or decreasing their numbers over time, they probably uh, demonstrated that. Having regular meetings, sharing the rationale behind the decisions, agreeing at least to some aspects. There may be 100 or more items that have to be negotiated, agreeing to at least a few aspects. Those things would be good indications of good faith bargaining. Again, none of those are required, but the National Labor Relations Board would be looking to see that at least there is the appearance of good faith bargaining. And so those are signs. Things that would tend to show a lack of good faith bargaining would be relatively few bargaining sessions, no uh, willingness to entertain changes, uh, not the sharing of significant logical reasons why they're making the certain proposals that they have, the failure to reach agreement on really any points. Those would be indications that one or both of the parties is not engaging in good faith bargaining. Now, it's pretty rare that unions don't engage in good faith bargaining. I'm not going to say it never happens, but it's not that common. But it is fairly common for unions to think employers are not engaging in good faith bargaining. And there may be some truth to that. Employers sometimes are tempted not to engage in good faith bargaining because having no agreement really undercuts the union's position with its employees, and it can diminish the position that unions have within that bargaining unit. So that's an overview about the collective bargaining process. Here we have information again for Quizlet of the mandatory subjects of bargaining. So these are going to be wages, the hours that are worked, and other conditions of employment, such as benefits, vacation or PTO, holiday pay, grievance processes, at will employment, those types of things, progressive discipline. All of these things have to be negotiated. An employer can't say, well, we don't want to negotiate about wages. If you're not negotiating good faith unless you're negotiating about wages. The employer doesn't have to change its position. It can say this is the wage, this is where we're staying, but they have to listen to the union. They have to explain how they came to that number, um, and there needs to be that process happen. Permissive subjects of bargaining are things that neither side has to agree to negotiate over. They can, but they don't have to. An example of that would be various workplace rules, health and safety rules. Um, we already talked about close shop. These are illegal everywhere. When I say illegal everywhere, I mean illegal everywhere in the US. There are other countries that have this. When we had the midterm negotiations, these are collective bargaining negotiations during the term of the contract. They can be provided for in the contract. We'll review the many times union contracts are 3 years long. We'll review, what the wages ought to be because obviously no one has a crystal ball. They don't know what the economy will be doing in, 2 years from now. Or the parties can open up negotiations just on their own to say, hey, this isn't working for us right now. Maybe there's been the pandemic hits, for example, and what needs to happen. No one had a crystal ball that this was going to happen, and so now people need to work from home. Well, there's nothing in the contract about that. I'm sure lots of union contracts cause people to say, wait a second, we need to think more about this. Or, what kind of PPE needs to be provided, um, personal protective equipment. And so issues can arise that nobody had any way of knowing would be relevant. And those would be called midterm negotiations. These are negotiations that happen during the term of the contract. Kind of like a midterm exam happens in the middle of the term, right? A management security clause doesn't always have to exist, but it's pretty common. that the parties agree that management, in other words, the company, will have the right to run the business and make appropriate business decisions as long as the appropriate laws and agreements, such as the collective bargaining agreement, are complied with. So the union doesn't get to say, well, we don't like the way you're pricing your product, or we don't like the new features you have on your, if you're a Ford Motor Company, we don't think the new features on this car are a good idea. If there's a management security clause, the union doesn't have an avenue for discussing those issues. Let's consider a couple of scenarios. So Mary has been involved in negotiations with the union representing her employees for 7 months. An agreement has not been reached on any issues, although Mary has made concessions from her original position. So Mary has given some indications of good faith bargaining. She is unwilling to make any further concessions. If no agreement is reached within a reasonable amount of time, Mary will likely not be liable for having committed an unfair labor practice because the law does not require an agreement be reached, only the parties agree in good faith. So if she's having regular meetings, especially if she's created those concessions, she's probably well positioned. Employers, when they start the collective bargaining process, are hopefully committed to collective bargaining in good faith. Uh, but they definitely want to create facts that create that appearance of good faith collective bargaining. So Mary probably thought about this long and hard. What concessions can I make from my original positions? Let me show by being involved actively in the negotiations. Those would be good ways of proving your case. But let's see the next one. The Steelworkers Local Union represents the employees at Crocodile Tile Corporation. The union wishes to negotiate a collective bargaining agreement over wages, hours, and working conditions. So these are mandatory topics. But Crocodile Tile refuses to even speak to the union. Under these circumstances, it's absolutely clear that Crocodile Tile is guilty of a ULP. If Crocodile Tile had been willing to speak but refused to respond to proposals, it would still be guilty of a ULP of failing to bargain in good faith. So here are some terms. Right to work state. We've already covered this. Again, if you haven't added this to your Quizlet, do so. A union shop. Um, this is different than a closed shop, so be sure that you're paying attention to these vocabulary terms. The union and management agree that employees must join the union within some period of time after hiring. So this is unlawful, and this is unlawful in right to not right to work states, but it's lawful in the other half of the states that are union security. So union shop is lawful, closed shop is unlawful. A union shop clause is what I've been calling a union security clause. It allows for a union shop. An agency shop is unlawful in Texas. It requires non-union members to pay union dues without having to be subject to the union rules. This is not. This is kind of like a union shop. You just don't have to join the union. But again, this is unlawful in Texas. And we've already talked about free riders. These are bargaining unit employees who do not pay dues, but whom the union is still obligated to represent. Okay, so let's consider this scenario. Garter Stake Industries approaches union representatives about scheduling midterm negotiations in accordance with the collective bargaining agreement. The union refuses to meet with management, claiming that there is nothing to negotiate. The union's refusal to bargain is unlawful because even though this is rare that the union refuses to negotiate in good faith, it can happen, and that would be a ULP if the union were to do that. Okay, so the actual agreement, when it's reached, is called a collective bargaining agreement, oftentimes abbreviated into CBA. Both the employer and the union must abide by the contract. It's just a contract, it's enforceable. Employees who feel that their contractual rights through the collective bargaining agreement have been violated may file grievances either with the union or either about the union, typically with the NLRB in that case, or through the union if their grievance is about the employers. The union and the management will review the grievance and resolve it according to whatever procedure the collective bargaining agreement provides. Oftentimes, there is an arbitration procedure once the various grievance steps are resolved. I've been involved in these, and they work just like a kind of a mini trial. There's an arbitrator who's appointed, there are witnesses, there's testimony under oath, documents are presented. It works very much like kind of a mini trial, usually quite a bit shorter than a traditional trial. The arbitrators that are hired for this, obviously they're not employees of either the union or the company, um, will, will likely follow past practice. If the terms of the collective bargaining agreement don't discuss a certain term, they'll see, well, what has the union and the employer done in the past in these situations? So, past practice, almost like a common law, oftentimes develops. So, even if there isn't anything in the contract about a particular issue, the arbitrator will use that past practice oftentimes to establish a precedent or a procedure that both parties have to follow. This is an interesting case um, that kind of shows how sometimes a collective bargaining agreement can limit employees' rights. Does an employer have the right to discharge an employee who refuses to permit the search of his vehicle parked in the company parking lot? In this case, the collective bargaining agreement did give the employer the right to search employees' vehicles when they are in the parking lot. Mr. Stykes felt that that violated his privacy rights. This was his own car. He didn't feel like that was right. But the, uh, the court ruled in favor of Chevron, saying that Stykes' privacy claim was preempted by the collective bargaining agreement. He had no reasonable expectation of privacy because he had access to the collective bargaining agreement, and the collective bargaining agreement made it clear that his vehicle could be searched. So you could see in this respect, Stykes had fewer privacy rights because of the fact he worked in a union facility than it probably he would have had if his workforce had been non-unionized. This is an example of how even if Stykes wasn't a member of the union, his rights were perhaps negatively affected in this case. Okay, so we've talked about collective bargaining, but we haven't discussed the issue about when a collective bargaining, when it fails, when the parties don't reach an agreement. And this is very common. I read somewhere, this statistic is somewhat dated, but half of the time a collective bargaining agreement isn't reached in the first year. So there can be, it's not like it's an automatic, okay, we've got the union, we'll have a contract in 90 days. Usually it doesn't happen, or oftentimes it doesn't happen that way. So an impasse is reached, again, another vocabulary term you want to add to Quizlet, is reached when negotiations have become deadlocked and both parties assume further negotiation would be futile. Now, the employer doesn't want to declare an impasse early on. The employer wants to continue negotiating as long as possible because if you declare an impasse super early, it looks like you're not negotiating in good faith. So it's important not to jump the gun there. The parties can agree to bring in a mediator to hopefully help the parties reach an agreement, but it's not a statutory requirement under the NLRA. It is a statutory requirement, actually, it's not a mediator, it's an arbitrator when you're talking about the railways and the airlines. But for the NLRA, it's not a requirement that you have a mediator come in. And even if you do, that mediator can't impose an agreement. Typically, what the mediator will do is make some recommendations about what he or she thinks is a fair outcome. But the parties can still say, nope, not agreeing to that. If the parties are unable to reach an agreement and a bargaining impasse is reached, then the employer can unilaterally implement its last, best, and final offer. So whatever was on the table by the employer can then become the law. So let's imagine that the workers are currently earning $15 an hour. The employer is willing to raise it to 16 in its last offer. The union thinks 17 is where the number ought to be. Until a impasse is declared, all the workers are still earning 15. The employer can't raise the pay while negotiations are ongoing. Even though the employer is willing to pay 16 and the union wants 17, the pay rate is going to stay at 15. But when both parties say that they've reached an impasse, then the employer has the option, if it wants to, of implementing the 16. And it doesn't just relate to wages, it could be other conditions of employment. Most negotiations do conclude without a strike being called, but certainly strikes can happen. When a strike happens, and usually that happens with the union members voting whether to strike or not. And if they vote to strike, typically a strike happens. So the strikers aren't quitting their jobs, they are just not coming to work because of a strike is happening. And the employer can't treat these employees typically. We'll look at some exceptions, but generally speaking, the employer can't treat the strikers as if they quit their jobs. And a private employer cannot terminate employees for engaging in lawful strikes. Unlawful strikes, yes. Lawful strikes, no. So let's look at some key vocabulary with respect to strikes. Um, so one term is picketing. You can have a strike without picketing, but usually you do have picketing with a strike. And picketing is when they're carrying the signs. Typically, they arrive at the place of employment, and they'll have signs that say that the workers are striking. And one of the reasons why they will picket is they will try to discourage other workers and also suppliers and other folks who interact, customers, for example, who interact with these businesses from using the services because that applies extra pressure on the employer to return to the negotiating table and to make concessions. The signs that the union members typically carry are going to include kind of what their grievances are. They may also just state what union they are members of. And many some of the picketing signs may talk about um, grievances that the union members have. For example, maybe the union feels that the wages are too low here. That would be an economic strike. Or the picketers may be complaining about unfair labor practices. Bob was let go from the company, and the picketers feel it was because he supported the union. Well, that would be an unfair labor practice, and so they might have signs that talk about unfair labor practices. We'll talk about the significance of an unfair labor practice strike later on in this presentation. So picketing may well occur. Sit down strikes are not a protected activity. So, as I said before, some strikes are protected, but some strikes are not protected. This would be an example of an unlawful strike. And this is when the employees aren't picketing outside, allowing the business inside to continue, but are actually taking possession of the workplace. They're sitting down inside and, kind of taking over the machines or whatever so that work can't be done. This is not a protected activity. The employer is likely to call the police to have these people escorted out, and these people under these circumstances can be fired. Also, wildcat activities are oftentimes illegal. This is a strike that is not sanctioned by the union. So, some individual employees who are um, part of a bargaining unit choose on their own to strike in opposition to the union. And oftentimes this happens when there's a provision in the contract, the collective bargaining agreement that the union and the company reached together. Typically, that contract, or oftentimes that contract, provides a clause that prohibits the union from striking during the term of that contract. And so the union can't support a strike in that situation, but the workers may individually decide, that this isn't, or whatever's happening isn't right, and they may stage a wildcat strike. Wildcat strikes are illegal if they force an employer to deal with the employees instead of the union. And federal government employees do not have the right to strike. Y'all are too young to remember this, but back when President Reagan was president in the 1980s, the air traffic controllers, who are federal employees, they're the people in the airports who monitor the comings and goings of airplanes. Anyway, they struck and they stopped working, and the president fired them all. So that is a lawful action, may or may not be a smart action, but it is a lawful action. Uh, U.S. U.S. postal workers may strike, but generally speaking, um, U.S. postal workers may bargain. may bargain collectively. But most federal employees cannot bargain over wages, hours, and benefits. And the same is true for Texas employees. Um, Texas private employee, I mean, not Texas private employees can bargain certainly, but Texas government employees cannot bargain. And as a result, we don't have many organized state employees in the state of Texas. So the rights that strikers have are going to turn upon whether they're economic strikers, in other words, they're striking about the wage rate that they're earning, for example, or if they're ULP strikers. So economic strikers who want, better working conditions. So you can see it's not always about economics purely. It could be about better working conditions. Are one category, and then the other are the ULP strikers, that they're striking about an unfair labor practice. Now, probably most strikes are a combination of these two issues. I mean, obviously, an employment relationship is complex with lots of different moving pieces. And so, usually, there's some aspects of both. And so, then it's going to turn on, well, what was the predominant aspect? The union is going to argue that it was a ULP strike more than anything else because the strikers are in a better position in that situation. The employers are likely to argue that it's an economic strike. This is an area where the union is in a better position to kind of shape the facts. We've talked about times where the company is in a position to shape the facts. This is one of the times where the union is in a better position. So those pickets that were being set up, if there's a ULP argument, you're going to have some pickets that talk about that. If there's any handbilling, there's going to be some mention of the ULP in that because those are emphasizing facts that are more helpful for the union. So the difference is that an economic striker may be temporarily replaced. That's also true for ULP strikers. They can be temporarily replaced. And by that I mean is while the strike is ongoing, the employer can hire other people to do the work. So let's say Bob is picketing outside. The employer, whether it's an economic strike or a ULP strike, the employer can hire Mary to replace Bob while Bob is picketing. That's clear. Um, but let's say Bob is just picketing for higher wages. Once the strike is over and Bob wants to return to work, the employer isn't required to let Bob return to work if the employer has replaced Bob with Mary. In that situation, the Mary can be entitled. It's the employer's decision, but the Mary can be retained. Now, if Mary quits 6 months later, then Bob can be hired at that point. So he's permanently replaced, but it's probably not permanently meaning for all time because eventually there will be an opening in Bob's department. And so in that situation, then the economic strikers will slowly be returned. But it could be weeks, months, even years before those openings happen. And so you can see that that's a pretty disadvantageous position for economic strikers. ULP strikers are in a better position because when they want to be reinstated, they have to be reinstated. So in this situation, let's say Bob is striking because of a ULP, the employer can still hire Mary temporarily, but as soon as Bob says, okay, I'm done, I don't want to strike anymore, I want my job back, then the employer has to let Bob return to his position, even if it means letting Mary go. Let's consider this scenario. The employers of Poodle Manufacturing Company are represented by a union. All the mechanics who work in the company's equipment work day who repair the company's equipment work day shifts, which means that if an equipment breaks down on one of the other shifts, Poodle has to pay overtime or suffer loss of production because no one's there to fix it. Poodle proposes to the union that the mechanics be assigned rotating shifts to solve the problem, but the union refuses. Then Poodle unilaterally changes the shift assignments in accordance with its proposal. So this is a situation that impasse was declared, and Poodle puts its last and best offer into effect. The union claiming a CBA violation. So they're saying, no, the terms of the collective bargaining agreement that was already in existence is inconsistent with what Poodle's doing. So in this situation, this would be a ULP to have, if the union is right, this is a ULP. So this union goes on a strike, alleging a ULP strike, and Poodle temporarily replaces the striking mechanics. This is definitely lawful, even if Poodle did violate the law with its unilateral change. The National Labor Relations Board later finds that Poodle did commit a malpractice, a ULP in this case. If the striking mechanics make an unconditional offer to return to work, Poodle must reinstate the mechanics because they were unfair labor practice strikers. Now, probably what happened is the NLRB is notoriously slow. It can take years for these decisions to issue. So, probably what happened is the striking mechanics made an unconditional offer to return to work, and they'd filed their ULP and they made an unconditional offer to return to work. Poodle said, "No, you're economic strikers. We will allow you to replace the temporary workers as the temporary workers leave, but you don't get back right now." Then, years later, the National Labor Relations Board issues its decision. Well, in this situation, Poodle will have to pay the back wages of these striking mechanics for all the time that the mechanics should have been working but weren't. So it could be years of back pay that Poodle would owe those workers under those circumstances. So it's really unfortunate for both the workers who have to, make their rent and buy groceries, that the NLRB is so tardy in rendering its decisions. It's also, as you can see, quite expensive for the employer. Let's talk about lockout. So this is another vocabulary term. So in certain circumstances, employers can legally lock out employees. This is kind of the employer equivalent of a strike. They are not allowing workers to come to work. So the idea is the employers literally lock the doors. The employees can't come inside. An employer cannot use a lockout as a means to avoid bargaining. So let's see a situation here. Blowfish Industries reduced employees' benefits as a means to cut costs. The union wanted to enter into a collective bargaining agreement, but Blowfish rejected its demands and refused to bargain and listen to the union's proposals. The following day, Blowfish locked the employees out. The lockout was a violation of the National Labor Relations Act because an employer may not engage in a lockout as a means to avoid bargaining. Now, what probably would have been lawful is if Blowfish had negotiated in good faith. There had been a give and take of negotiation, but the parties reached an impasse. In that situation, a lockout is more likely to be upheld. It's still a risky move for an employer to have a lockout, but it's a possibility. We've already talked about this possibility too, the no strike clause, no lockout clause. It's a clause in a collective bargaining agreement in which labor and management agree that the labor will not strike during the term of the contract and the management will not stage a lockout. And again, this is how you get the wildcat strikes because the union's hands are tied during the term of the contract if this clause exists. They cannot recommend a strike. Employees do have the right to picket, but this right is not without limitations. So let's look at some ways that you can have an unlawful picketing situation. So this would occur when you have massive number of pickets that the non-strike workers, which are oftentimes called scabs. This is a derogatory term, so I'm not going to use it again, but you may have heard it in the larger culture that obviously this is an offensive term, but just for the purposes of communicating clearly what the vocabulary is, this is a derogatory term to refer to workers who cross the picket line. So it can become so dense that workers literally cannot enter the facility. Now, it's okay that there are strikers, and so the employees find it emotionally difficult to cross the picket line. Many employees would like to cross the picket line but choose not to because they don't want to interact with their coworkers in that way. But if they literally can't, either it's not safe or the people are too dense that logistically you just can't get there, then that would be an unlawful picketing. If there are any threats of violence or actual violence on the picket line, that would be unlawful picketing. And fining or expelling union members for crossing the picket line. that would be, that's obviously done by the union. That is a violation of the picketing rules. Now let's talk about unfair labor practices. Okay, so we're going to, as you may recall, initially under the Wagner Act, only employers were there defined unfair labor practices that the employers cannot commit. Those remain in force, but we'll see that eventually the union was also held, or was there were limitations on the union's activity in these areas as well. So let's look at what the employer unfair labor practices can be. Well, one is refusing to bargain in good faith. One is engaging in activities that could tend to attempt to control or influence the union. So imagine that an employer started, and this used to happen. Hopefully, it doesn't happen anymore, but this used to happen that the employer would pay off union officials. Hey, we can't afford to raise rates. We'll give you, president of the union, $10,000 if you will agree to a contract that doesn't include wage increases. You can see how that is unlawful for both the union and the employer to engage in. But it could be more subtle things than that. Also, the company can't engage in union's affairs. For example, the employer can't try to get a certain candidate to be elected to a union office. The employer should be completely separate. It's almost like we don't want Russia meddling in our election. We don't want China meddling in the U.S. election. The employer shouldn't be meddling in the union election. And of course, the employer cannot be discriminating against unions who want to join the, discriminate against employees who want to join the union or who are especially active in the union. And this is especially important during the union campaign. Again, we talked about strikes and lockouts. Both are legal if they are primary. Let's consider these scenarios. So the Living Institute has a policy that prohibits any employee, whether or not it represents the union from distributing any union literature or any union notice. It is also stated that employees may be dismissed for supporting or joining a union and that they should address any issues using the formal complaint process. Under these facts, it's very, very clear that this company has committed multiple ULPs by trying to coerce the employees out of exercising their rights under the National Labor Relations Act. So this is a very straightforward case. A union targeted manatee manufacturing for a union campaign. The union organizers contacted Bob, a worker there, to assist them in the process. When managers at Manatee came to know that Bob was working for the union, they fired Bob because Bob's union activity. They also instituted a new rule requiring employees to leave the company property within 15 minutes after the end of their shift unless speaking with a member of management. So both of these activities are ULPs. Firing Bob because of his union activity, very, very clear. Changing a policy about access to the company property would also be a ULP. If the company had had this rule about all employees have to leave within 15 minutes, it is arguable that enforcing a policy that you've consistently enforced might be lawful, but even that could be dicey because obviously employees might want to be handbilling their coworkers in favor of the union beyond the 15-minute point. So here is just a description of what the elements are for discrimination under the NLRA. The employee had to engage in protected activity. The employer has to be aware of it. You can't discriminate against something you're not aware of. The employer has to demonstrate hostility toward that activity, and there has to be some connection between the hostility and whatever the negative outcome is. This is a prima facie case, just like we talked about with the employment cases. And again, the employer will have the opportunity to show that the same decision would have been made regardless of the employee's engagement in the protected activity. Now, we've talked about this framework and we talked about the EEOC's analysis in discrimination cases. I think I said that the vast majority of discrimination charges are resolved by the EEOC with a no probable cause finding. Most of the time, the EEOC finds no discrimination. I would say it's just the reverse with the NLRB. The NLRB is a little bit more skeptical about employers, which may be a good thing, maybe a bad thing, but it's just a thing. So if these things are satisfied, um, it's very likely that the NLRB will find that there has been a ULP. It's kind of an uphill battle for an employer to be acquitted when these actions have happened, even in cases where maybe there wasn't an unlawful activity. Um, let's look at what a labor organization is. So here's our definition. If you don't have it in Quizlet yet, please add it. A labor organization is, well, an organization, naturally, in which employees participate and which exists for the purpose of dealing with employers regarding grievances, labor dispute, wages, rates of pay, hours of employment, or work conditions of work. So there's no big surprise there. But let's talk about employee participation groups, because these are very commonly exist, especially in industrial facilities. And frankly, they exist in part as union avoidance tools. These are groups within a facility that are designed to address specific issues. For example, they may be a safety group within, and it may have both management and non-management in it. And the group tries to brainstorm, how can we make this place safer? And so they'll look at data about, well, what have people, what are the statistics about injuries here? What types of injuries have happened? Why have they happened? And they may brainstorm ways of reducing it. It makes sense to include non-management in these committees because they have special expertise. They know what really happens and why people do what they do. Um, but it is also good from a union avoidance perspective because it makes the hourly workers feel empowered, that they are participating in their work environment. Um, these organizations, though, can be held sometimes to be unlawful labor organizations. And the big case in this area is electromation. We would talk extensively about this case if we had more time, but we don't. But electromation is a case that held that some of these groups could be considered, and many times they're called quality circles. It's a common term for them. That they're considered basically labor organizations that are dominated by the employers, in other words, dominated by management. So if you are having a client that is wanting to use some of these quality circle groups or whatever, uh, they need a lot of guidance as to how to do these types of activities so that they don't run afoul of this type of case law. It can be done, but it has to be done carefully. So now we're going to talk about what unions can't do. So again, this is an addition after the Wagner Act. So this comes from the second law. We had the Wagner Act during the Great Depression, and then we had Taft-Hartley after World War II, still in the 1940s. And this was, again, a fairly anti-union law. So again, they're trying to address what they perceive to be union excesses. So unions commit unfair labor practices when they restrain or coerce employees in the exercise of their rights under the NLRA, when they cause an employer to discriminate against an employee for the purposes of encouraging or discouraging membership in the union, when the union refuses to bargain collectively, and when they broaden labor disputes to include neutral employers. So let's spend some time talking about secondary boycotts. This is another term that belongs on Quizlet. A secondary boycott is, first of all, illegal in the United States, not necessarily in other countries. It is illegal union pressure on management created by getting others who do business with management to cease doing business. Um, so imagine that um, I am, uh, let's see, I make widgets. I have a widget factory. It's not unionized. And I don't sell widgets directly to the population. I sell my widgets to other businesses. And some of the businesses to whom I sell are unionized businesses. Their workforces are unionized. So there's a union campaign in my facility trying to organize my workers. I am resisting the union campaign. Well, the union could go, let's say it's the same union or even a different union that's sympathetic to my union. or not to the union that's trying to organize my facility. And so it goes to some of these unionized companies and say, listen, we're going to strike you, or we're going to create difficulties for you if you continue to buy from this from Groover's company, because it's not union organized and we want it to be. And so we know that if the company loses a lot of its business, it'll cave in and agree to our representation. It'll agree to a card check instead of requiring an election, which we're worried we'd lose. And so this is how a secondary boycott would occur. A secondary boycott is unlawful. Uh, the union cannot do that. So here's an example that will help clarify some of these points. So Red Weasel bids on a job to install a heating system for a new office building. Aardvark Construction is a general contractor and is responsible for hiring subcontractors such as Red Weasel. So Red Weasel would work for Aardvark if Red Weasel gets the deal. Aardvark construction workers are represented by a union. Red Weasel is a non-union employer, and it is currently rebuffing efforts by the union representing Aardvark to allow its workers to organize. Again, it's not accepting a card check. The union sends emails and letters to the workers of Aardvark Construction, in other words, the main contractor, asking them not to report to work until Aardvark Construction rejects Red Weasel's bid and instead chooses a union subcontractor. Under these circumstances, the union has committed a secondary boycott. Hopefully this story, so if what I said before about secondary boycott doesn't click with you, this example, I think it's easier to think about a secondary boycott if you're thinking about an actual example. This example might be of assistance. So here are some additional things. We have our first four here. Let's go on and look at the rest of the list. So unions cannot charge excessive fees or excessive initiation fees or excessive dues. Again, the common amount is 2 to 3 hours a week, which works out for full-time workers to be about 1%. Usually there's not a deduction if the worker is part-time, so part-time workers often pay a higher percentage of their wages to the union. So unions must not cause an employer to pay for work not performed. This is called feather bedding. This is unlawful. I don't think I necessarily have this, but this is another good term to add to your vocabulary. It is an unfair labor practice for unions to cause an employer to pay for services or goods that were not provided. And then finally, picketing for more than 30 days for the purposes of obtaining union recognition. So on the 31st day, it becomes unlawful, but the first 30 days are lawful. The idea is, well, the union could have an election within 30 days anyway. So why are they picketing for more than 30 days? They should just request an election instead. Okay, so here's another case. This is a Supreme Court case. This is the exchange parts case. Does the NLRA prohibit an employer from offering benefits? So we're not talking about threats. We're thinking about the tips thing. We're talking about the P here. Offering benefits to employers to sway the outcome of a union representation election. And the answer is very clearly yes. So the employer can't say, if you don't vote the union, we'll give everybody an extra $1 an hour. That would be unlawful. The National Labor Relations Act prohibits not only intrusive threats and promises, but also conduct immediately favorable to employees for the purpose of influencing a union representation election. So let's say instead of making a promise, hey, we'll increase your wages if the union doesn't go into effect, let's say the employer says, you know what, we're just going to increase everyone's wages now, before the election. We don't know how the election is going to go, but we're going to vote to increase wages now. That's neither a promise or a threat. you're actually doing something, but that is still unlawful. You can't improve or solve the problems that the employees have brought to your attention. You have to maintain those laboratory conditions. You have to maintain the status quo. So you don't need to know exchange parts of the name, but you do need to know the holding of this case. So we have now gotten through the Wagner Act. We still have most of the Taft-Hartley to go through and Landrum-Griffith, but we finished most of the material. Again, I'm not going to require that you know whether a particular legal protection or issue is in which part of these laws. It'll just be because they're all part of the NLRA. So you don't need to know the particular sections, but I think it's helpful for understanding it to be aware of these sections. So we've done the most important part for sure. And again, in our first lecture, we covered the history of unionization and we did an overview of the Wagner Act part of the NLRA. In this session, we've talked about union campaigns and elections, the collective bargaining process, strikes and picketing, and we've discussed the ULPs, both that can exist for the employer and for the union. In our next lecture, we will cover the Taft-Hartley Act. Again, these are amendments to the NLRA, and we'll talk more about the right to work laws. We've kind of covered that pretty well, though, so we won't do much more. We'll also discuss the Landrum-Griffith Act, which is also an amendment to the NLRA that happened in the 1950s. And we'll discuss public sector unions briefly. I hope that this presentation has been helpful. I thank you for your attention, and I hope that you have a wonderful day. Let me go ahead and stop sharing. Thanks.